Now we can go to another reason why we would prefer an amicable approach to an adversarial approach. So let's read. Mediation is also user-friendly. The process is flexible, which makes it adaptive to the needs of it and requirements of specific conflicts. Also, the power in mediation to determine procedure, time frame for settlement, times of reference of the mediator, outcome of the mediation, and other issues in the process. This power always lies with the parties. They maintain control over their conflict from the beginning to the end of mediation. This contrasts with an adversarial mechanism where power lies entirely with a third party. We have already shown the cost-effective advantage of mediation in one adjudication panel I sat on. The winner was awarded damages and cost in a sum smaller than its fees. I have also seen, and I have also been an attorney for many years, and I know that adjudication or litigation, arbitration can be a drain on clients' resources. That is, and I read here, that is how the system operates. Its adversarial systems tend to be expensive. There's also the advantage of speed of resolution in mediation. An adversarial mechanism such as adjudication is slow. Why? In order not to lose, parties want to put in all the ammunition necessary to secure a victory. Victory, of course, in quotes and inverted commas. And I explained why earlier. It's Pyrrhic. It's not real victory. This sometimes leads to many postponements before the exhausted winner emerges. This is the story all over the world. I do not know of one country where speed is synonymous with litigation or arbitration, in both of which we are faced with the problem of a slow and inefficient legal system, unquote. That quote is from Kenneth Sinclair of Hawker forgive me, Kenneth Sinclair of Hawker Siddeley Power Engineering Limited. That's the experience of a user of both systems. And they've used an adversarial system, they've used an amicable system, and this was their outcome. They feel that in an adversarial system of conflict resolution, they are faced with the problem of a slow and inefficient legal system. I think that's a very fair comment from my own experience. At mediation, there's a level playing ground. Sharp practices by either side is removed. They need to be underhand or to surprise or set booby traps. They need to secure a technical advantage over the opponent in order to defeat him. All these do not exist as they do in an adversarial system. They don't exist because at mediation, at amicable dispute resolution, the perspective is that of seeing the conflict as a joint problem of the parties, and therefore approaching it as joint problem solvers, never as antagonists, as is the case in adjudication and other adversarial systems. So what are we saying here? Why an adversarial system is not user-friendly is because it's not flexible. And that's why an amicable process such as mediation is preferred, because it is adaptive to the needs and requirements of specific conflicts, and of course, specific parties. The fact that it is also that the power to determine procedure, time frame for settlement, terms of reference of the mediator, and the outcome of the mediation and other issues in the process. The fact that this power always lies with the parties. The fact that they maintain control over their conflict from the beginning to the end of the amicable dispute resolution process makes it mediation and other amicable dispute resolution mechanisms and user-friendly. And an adversarial mechanism is not like that. Even if, like in arbitration, you begin with the parties determining who is their arbitrator. Once the arbitrator comes in, generally he becomes or she becomes the one that decides the process for the parties. It is true that the arbitrator must consult with the parties, must let the parties carry the parties along as to what it is doing, but it only goes so far. When there are issues, as to whether or not the process should go in a particular direction, including whether or not the arbitrator themselves should continue to be retained, should continue to determine the dispute resolution process. There's a large latitude given to the arbitrator to determine its own power to arbitrate. It's very clear. The power of the arbitrator to continue to determine its jurisdiction, at a time in the process where he, the arbitrator, or she, the arbitrator, is empowered to determine that. And that's very settled in arbitration. But in mediation and other amicable processes, likely even the power to continue to be the third party in the mediation from the beginning to the end, as long as an agreement has not been reached, the parties could have that, retain that control over who is the third party helping them to resolve the dispute. So those one or those two differences, are determine which of the processes adversarial or amicable is user friendly. And we don't ever want to forget that the decision in arbitration, generally in arbitration, is made, the final decision is made by the third party arbitrator, not by the parties. Whereas in mediation and other amicable dispute resolution mechanism, it is the parties that determine the outcome. Those are very fundamental differences that determine which is more user-friendly. Again, I read that the cost-effective I read about the cost-effective advantage of mediation, and we've dealt with that earlier in the last chapter or two, where we said that because it is faster, because it is more friendly, because people are not looking for a determination of who is right, who is wrong, they're able to resolve their dispute more quickly. And this means that the amount of resources expended on amicable dispute resolution mechanism, notably mediation, is less compared to what you spend in an adversarial system. When we spend less time, when we are focused on the problem and not on the people, then we have a more cost-effective situation compared to adversarial systems like the court, like the average arbitration. We also have here this advantage of speed of resolution at mediation, at amicable dispute resolution, which I just touched on. An adversarial mechanism such as adjudication is slow. Why? Because parties have to win or they lose. It's not a win-win situation. And so what do parties do? They want to put in all the ammunition, they need to secure a victory. And the meaning of that is that you could have several postponements before the exhausted party winner emerges, especially in litigation. Arbitration could be slower, but it could also take time. There's an arbitration that involves a country, recent arbitration that involved a country and a company. And yes, the arbitration is over, but the parties are back in court. Disputing over and litigating over whether or not the arbitration should have taken place in the first place, and whether or not the victorious party should be paid what it won. And the matter, I believe, has been going on for about 5-6 years. But it is not conclusive. Why? It is an adversarial system that the parties elected to use. And everybody wants to win. Even after you win, you still have to fight to get the booty of victory. And the person that loses, the party that loses, keeps fighting to avoid paying what it's been adjudicated to that it should pay, or they should pay to the victorious party. And as I said in the book, this is the story all over the world. I do not know of one country where speed is synonymous with litigation or arbitration. And I've cited a user who said, in adversarial systems, you are faced with the problem of a slow and inefficient system. At mediation, there's a level playing ground. Sharp practices by either side is removed. the need to be underhand or to suppress or set public traps, the need to secure a technical advantage over the opponent in order to defeat him. All these do not exist as they do in an adversarial system. They don't exist because at mediation, the perspective is that of seeing the conflict as a joint problem of the parties and therefore approaching it as joint problem solvers, never as antagonists, as is the case at adjudication and other adversarial systems. So this speaks to what I guess I mentioned already. Everybody doing everything to win, to surprise the other party, to gain technical advantage over the opponent, to defeat the opponent. All this negativity do not exist as they do they do not exist in mediation as they do in an adversarial system. I know that courts and judiciaries have taken pains to reduce the time of litigation. New civil procedure rules have been enacted, here and there. But the truth is that, from my experience, 32 years experience in the litigation industry, I know that these rules have only gone so far. They've not really addressed the fundamental reason why cases in adversarial system, where disputes in an adversarial system, such as in court, why they entail so much acrimony. It is because in those adversarial systems, somebody has to win, somebody has to lose. Nobody wants to win. Whereas in non-adversarial systems, in amicable systems like mediation, victory or losses are not the focus. It's not the amicable systems like mediation are not designed to determine winners and losers. If there must be issue of winners, there are no losers, of course. If you have to talk about winner, it should be a win-win situation, not a winner and a loser. Because the focus is to look at what is the problem and work together to resolve it, not as who is the problem, who is wrong, who is right. I'd like you to think more about these challenges that I'm raising, here and in the book, to focus. I'd like you to focus on why is an adversarial system like the court, and sometimes even arbitration, why are they problematic? And I reckon you will find out it's for the reason I just gave you. They're adversarial because they're adversarial and therefore problematic because the adversarial systems are looking for winners and losers. You don't go to war, you don't go to court or to arbitration to help your opponent win. No, you are there to beat them down, to defeat them, to make them lose. And you are there to make your case look good, make your side look good, to defeat the opponent, to be the victor. So it's different paradigms. One is a paradigm of solving the problem of both parties and providing for their needs. One is the paradigm and perspective of determining which of the parties is wrong, who is right. So very opposed paradigms. Very, very opposed. And it's very important for us to understand that, especially those of us who have to help parties resolve their disputes. I think we should stop there. And I invite you to please make your comments, post your comments. I also counsel that you get a copy of this book, How to Resolve a Conflict. It's on Amazon. You can get, you can read freely. You don't have to pay if you have a Kindle. We have the arrangement to make it possible for you to. We have an arrangement with Amazon to allow you to read a book free of charge. But if you want to have a soft copy, of course, you can get one at Amazon. You can purchase one at Amazon. And if you want the hard copy, it's also available. So as I said, we'll stop here and then we'll continue the lectures tomorrow. Thank you for joining me today.